Ladies and gentlemen, today we have Mr. Mubiru Musoke again. This is the Uganda Federal Union. And today, Mr. Mubiru Musoke is going to talk about the participation of Attorney General and the DPP in state terrorism. Mr. Mubiru Musoke is an attorney, so he knows what he's talking about. In his past presentations, he talked about federalism, Uganda's remaining lifeline, federalism in Uganda, and the sovereignty of the people, the legal foundation of federalism. Museveni is a state terrorist. And in one of them, he introduced UFU, Uganda Federal Union, to Ugandans. So today, he's talking about participation of Attorney General and the DPP in state terrorism. Mr. Mubiru Musoke, are you there?
Thank you very much, Mr. Moderator. Today's topic, as the moderator has pointed out, is a participation of the Attorney General and the Director of Public Prosecution in state terrorism. It is a shocking revelation to discover that the chief guardians of the rule of law in Uganda are actively involved in the promotion and perpetration of state terrorism. This shocking discovery is, however, not surprising when you look at all the facts, the history, and the causes of state terrorism in Uganda, as we shall, in our conclusion, point out. Even worse, when one understands when state terrorism started in Uganda with the colonial security policy, which Apollo Milton Obote embraced, inherited, and institutionalized after independence. State terrorism got worse under Idi Amin, and nobody could believe that it could even get worse than what it was under Idi Amin. Today, it is under NRM, we have what we may call cold-blooded state terrorism, which is disguised as security policies by the people who went to the bush supposedly to fight for democracy in Uganda. Let us look at the incontrovertible facts of state terrorism as manifested under Yoweri Kaguta Museveni. Article 119 of the Constitution of Uganda stipulates that the Attorney General is the principal legal and advisor of the government. Under that broad role, the function of the Attorney General includes giving legal advice and legal services to the government of on any subject. Under that wide spectrum of the functions of the Attorney General, he is responsible for ensuring that Uganda faithfully implements her treaty obligations, especially those regarding the protection of human rights. But even more important, the Attorney General represents the government in courts or any other legal proceedings to which the government may be a party. Most recently, the Attorney General played the role of the hatchet man. He disclosed to the cabinet a draft law intended to amend the Constitution to remove from the Constitution the right of an accused to apply for bail within the earliest possible time under the Constitution. The role of the Attorney General in this nefarious function showed that in his advice to the government, the Attorney General has no legal backbone. The current Attorney General is a puppet who does not, he does whatever his master desires or even demands, regardless of what the law stipulates. That means that the Attorney General has neither the legal capacity nor the moral integrity to offer an honest legal advice or opinion in view of the obligations of Uganda to abide by the terms of the treaties Uganda is a party to and protecting human rights, such as the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. Under Article 1 of the Universal Declaration of Human Rights, all human beings are born free and equal in dignity and rights. Equal protection of the law is guaranteed under Article 7 of the Universal Declaration of Human Rights. Arbitrary arrest is prohibited by Article 9 of the Universal Declaration of Human Rights. However, that is what is going on in Masaka today does not only violate the provisions of the Constitution of Uganda protecting these rights, but also Ugandans like the Reverend Father Mugisha have been charged with concocted charges of murder. That abuse of power is a violation of the Constitution of Uganda and Uganda's treaty obligations. Unfortunately, the Attorney General, Kiryowa Kiwanuka, should not be a stranger to this form of state terrorism. To the best of my knowledge, the grandfather of Attorney General George Kiwanuka disappeared under Amin's state terrorism. I would therefore have assumed that the Attorney General, Kiryowa Kiwanuka, being a victim of state terrorism himself, and in the memory of his grandfather, would dedicate his entire life, especially as an Attorney General, to ensuring that state terrorism is never repeated or tolerated under any circumstances in Uganda. Moreover, the Attorney General should be the first person to ensure that the government of Uganda strictly conforms to her treaty obligations, which I have just cited, and the principles of the rule of law enshrined in the 1995 Constitution. Moreover, Article 28 of the Constitution of 1995, which was literally borrowed from the provisions of the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, provides for the right for a fair trial. and guarantees the protection of human rights in Uganda, and by implication tries to ensure that the avoidance of state terrorism at any cost. However, when we look at the Office of the Director of Public Prosecutions, the situation is even horribly far worse. Under Article 120 of the 1995 Constitution, the DPP is a person qualified to be appointed a judge of the High Court. This constitutional requirement means that the person appointed as a DPP should be professionally and morally superior to a politician like the Attorney General. The Attorney General is expected to be and behave as an ordinary politician sitting in a cabinet. The DPP, on the other hand, is expected to be very different in view of the importance of the rule of law in democratic countries. The DPP is supposed to be above politics. He should be insulated against political influence. The DPP in his professional activities is expected to be honest and generally a person with impeccable professional credentials. However, in Uganda, those higher ideals and expectations of moral integrity, due to pervasive corruption, have not always been respected or even adhered to by the Attorney General and the Director of Public Prosecutions. The previous person to occupy the office of DPP, Mike J. Shikiba, first worked as personal legal counsel to President Museveni. He was subsequently appointed a judge and promoted to the Supreme Court. However, when we trace Justice Shitiba's background, we find that while he was working as the DPP, many acts of state terrorism were committed on his watch as a DPP. For example, under his leadership, civilians were prosecuted before the court martial, even though Article 28 of the 1995 Constitution, which guarantees fair trial, prohibits the prosecution of civilians in military courts, and the Constitutional Court has ruled to that effect in July this year. Prosecuting civilians in military courts is one form of terrorism, state terrorism. Unfortunately, it is also a trademark of NRM illegal regime policy implementing state terrorism in Uganda. For example, the oath of the judges of the military court, the court martial, requires them to pledge their allegiances to the president rather than to the constitution. Judges of the court martial are therefore neither impartial nor independent. They cannot protect the rule of law. They serve at the pleasure of the president, and they are mainly concerned with issues of dealing with the discipline of soldiers rather than the rule of law. So why should you prosecute Ugandans in the court martial, except if you want to intimidate people with state terrorism? That would be the only explanation why the Director of Public Prosecutions uh, prosecutes civilians in court martials. The duties of the Director of Public Prosecutions under Article 120 of the 1995 Constitution include to direct the police to investigate any information of a criminal nature and to report to him or her expeditiously, and to institute criminal proceedings against any person or authority in any court with competent jurisdiction other than a court martial. This provision has been ignored by the DPP. It is important also to point out that in exercising his or her powers under the article of the Constitution, the Director of Public Prosecution shall have regard to the public interest, the interests and the administration of justice, and the need to prevent abuse of the legal process. However, in the most recent prosecutions of the members of the political opposition, the DPP has been busy abusing the legal process in bringing concocted charges against members of the political opposition. This has been going on despite the fact that in the exercise of the functions conferred on her or him or her, that is the DPP, shall not be subject to the direction or control of any person or authority. But the practice has been the opposite. The law is very clear that in performing his or her duties, the DPP shall have the same terms and conditions of service as those of the High Court judge. Now you can see that the law went out of its way to make sure that the DPP is insulated from politics. But what we see today is the DPP behaving as if the provisions in the Constitution don't exist, and as if he is a politician, which he is not supposed to be. These constitutional provisions have not only been neglected, but also abused by those who have served the NRM regime in that capacity since 1986. For example, during the two court sieges in our history on November 15, 2005 and March 1, 2007, the DPP was informed and was fully aware of the illegal invasion and siege of the High Court. The DPP was in fact in direct contact with the thugs that carried out the illegal court invasion and tortured the detainees inside the High Court itself. So you can see that our officials, our legal guardians of the rule of law, are the violators of the rule of law. They are accused on both occasions, that is 2005 and 2007, were denied the right to bail and were severely abused inside the High Court itself. What happened on November 15, 2005 and March 1, 2007 was state terrorism at its worst, in its worst manifestation. In fact, one of the prosecutors who was an employee of the DPP's office in 2005 and had filed the concocted charges against the innocent people was none other than Justice Byamukama Mugenyi Simon, who is now the chairman of the Electoral Commission, who was appointed a judge of the High Court in 2008, 3 years after he blatantly violated his oath as an officer of the court and as an employee of the Department of Public Prosecution. What is happening in Masaka at this very time when I'm talking is a fully fledged operation of state terrorism involving at the highest level the Director of Public Prosecution office headed by Ms. Jane Frances Abado. A lot of people have been murdered, supposedly by unknown terrorists in Masaka. 2 MPs who do not even come from Masaka have been charged with terrorism and murder of some of the deceased in Masaka. We know that the current DPP, Ms. Jane Frances Abado, is fully aware of what is going on in Masaka. Since the 2 MPs, Alan Sewanyana and Mohammed Segirin, were under detention after their first application for bail was nullified because they were rearrested on new charges, new false charges of terrorism and murder, obviously with the full knowledge of the DPP's office. In addition, the Reverend Father Richard Mugisha has been charged with murder himself. Excuse me. Can you believe that? All these unbelievable stories are actually true and reflect the gravity of state terrorism in Uganda at this point in time. Clearly, the 1995 Constitution has been violated by the people who are supposed to enforce the law and protect the citizens' human rights. Article 120 provides that in exercising his or her functions, the DPP shall not be subject to the direction or control of any person or authority. This provision is very important in the enforcement of the rule of law. The prohibition of any direction or control of the DPP incumbent by any person or authority was intended to insulate the DPP from politics and especially the influence of his or her superiors, namely the Attorney General and the President of Uganda, who are politicians, who are partisan politicians, and who at this time, we can conclude that they are in charge of and responsible for the ongoing state terrorism throughout Uganda. We are again sadly reminded about what happened on November 15, 2005 and March 1, 2007, when the DPP acted more like a partisan politician than an impartial law enforcement official. The previous abuse of the DPP's office is directly related to what is going on in Masaka today, and it leaves no doubt in my mind that the Director of Public Prosecutions has been under the control of both the Attorney General and the President of Uganda in violation of the Constitution provisions which try to insulate the Director of Public Prosecutions from politics. One important question to answer in our conclusion is, what are the causes of state terrorism in Uganda? There are two major causes of or factors promoting state terrorism in Uganda. The first and the most obvious is corruption, which has encouraged the politicization of law enforcement. It is easy to commit state terrorism when public officials and politicians are corrupt and subservient to their leaders, or when they are put in a situation where they are likely to profit from corrupt activities. Uganda is rated by Transparency International as one of the most corrupt countries in Africa and the world at large. Corruption in Uganda, unfortunately, is one of the most prolific sources of illicit livelihood, especially for civil servants, government officials, and politicians. In this category are the politicians and the civil servants who thrive on economic parasites, who illegally extract state resources for their personal benefit. Politicians and civil servants in Uganda have been corrupted, and as a result can easily succumb to temptations by extracting short-term material gains from any source available to them instead of hard work in the long term. Corruption is now a thriving business and has become organized crime in Uganda. The second factor causing substantially contributing to state terrorism in Uganda is the personality of the leader of Uganda, Yoweri Kaguta Museveni. Pathological leadership resulting from what psychiatrists call obsessive compulsive personality disorder is primarily the cause of Uganda's leadership problems. Obsessive compulsive disorder is manifested in preoccupation with personal control at the expense of freedom, flexibility, and openness or in one's conduct. At national level, obsessive compulsive disorder inevitably results in tyranny, in dictatorship, and state terrorism. We believe that Yoweri Kaguta Museveni severely suffers from obsessive compulsive personality disorder. That's why he has amended the constitution twice to remain in power. That's why he's trying to amend the constitution in order to abolish the right to bail. The disorder, this disorder of the compulsive disorder, the obsessive compulsive disorder, may be detected in Museveni's unwillingness to retire from politics after more than 3 decades in power. So obsessive compulsive personality disorder, for example, explains a series of amendments to the constitution by Museveni to stay in power. It explains his conduct today to engage in state terrorism. He does not want his political opponents to gain a footing or support of the people, so he destroys them. He uses state terrorism not only just to scare them, but to imprison them illegally in violation of the law. So Ugandans must be ready to deal with this situation. We have to remember that nobody will liberate Ugandans. We must liberate ourselves from Museveni. We must work hard. We must be determined. We must be courageous enough to fight Museveni. He's not impossible. If Saddam Hussein is gone, if Hitler is gone, if Muammar Gaddafi is gone, who is Yoweri Kaguta Museveni who can't go? He will go, and we are ready to deal with him and make sure that he goes forever and leaves Ugandans to enjoy their human rights in peace. Thank you for listening. I will be back again to make another presentation or for the Uganda Federal Union on a topic like the one I've just concluded today.